You paid for the work, but do you actually own it? Whether it's software, branding, or a website, if you're hiring designers or developers, there's a legal trap that could cost you your rights to what you thought you bought. In this video, we'll uncover the surprising truth about who really owns the intellectual property and the simple contract clause that puts you back in control. Let's talk about another type of service contract you might have. You may hire a designer. Maybe it's a web designer, maybe it's a graphic designer, maybe it's a software company. Let's use that as an example. There's a company who spent $100,000 asking a company to develop software for them. They paid them $100,000. They got the software. You might think it's all good, right? But who owns that software? What you might not realize is that the general rule in the United States is if you hire a contractor to do something for you, they own the copyright, the intellectual property rights in whatever they design for you. Now, they might allow you to use it. But if you are paying $100,000 for some software code, you are probably assuming you own that. Now, if your employee wrote the code for you, then generally speaking, your company would own that code, as long as the employee did that as part of his or her job. But if you hire a contractor to write software code or music or do graphic design or prepare a website or whatever that might be, the general rule in the United States is the contractor owns the intellectual property rights in what they created. This even includes a photographer. If the photographer takes photos of your office space or your staff, under the law, the photographer owns the copyright to all of those photos. Now, there is something you can do about that. So here's the tip. Include a work made for hire provision in your contract with the independent contractor. A work made for hire provision basically says, look, this work that you're preparing was made by you for us, so we own the rights to it. That's what a work made for hire or a work for hire provision means. You can find it on the internet, but it basically says all copyrights acquired for this design or this software or photo or whatever it is are owned by us, not by you. So you can reverse the default rule simply by having in your contract with anybody who provides services to you a work made for hire provision. Now, if you'd like to know more about how to avoid trouble like this, I have a free resource at aaronhall.com/free. I provide information for business owners of small to mid-sized companies on how to avoid common legal problems. That includes a PDF. It includes videos talking about important issues. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurial companies. If you'd like, subscribe to this channel so you can get more educational content like this.